Just a moment.
Good morning and welcome to the Maryland Public Service Commission. We are on the record in case number 9645, Baltimore Gas and Electric Company's application for a multi-year rate plan. We'll begin today by taking appearances of the parties, and then we'll take appearances by those who filed petitions to intervene. So let us begin with counsel.
Good morning, Mr. Chairman. Lloyd Spivak for the Commission staff. With me today and in the case will be Annette Garofalo, Michael Dean, and Leslie Romine.
Thank you, Mr. Spivak. Counsel for Office of People's Counsel.
Good morning, Mr. Chairman. Joseph Cleaver on behalf of the Maryland Office of People's Counsel. I'd also like to enter the appearance of Paula Carmody, William Fields, Anna Ryan, and Gary L. Alexander for the Office of People's Counsel.
Thank you, Mr. Cleaver. Counsel for Baltimore Gas and Electric Company.
Good morning, Your Honor. David Ralph on behalf of Baltimore Gas and Electric Company. I'd also like to enter the appearances Daniel W. Herson, Jessica Raba, and Christia H. Ravenel. Also like to note the appearance of Beverly A. Sikora, who is entering her appearance pro hoc vice.
Thank you, Mr. Ralph. We'll move to those who have filed petitions to intervene. Is a counsel for United States Department of Defense present?
Yes, Your Honor. John McNutt, Department of Defense.
Thank you, Mr. McNutt. Next, do we have counsel for the National Railroad Passenger Corporation?
Morning, Your Honor. Bob Weissar on behalf of Amtrak.
Thank you, Mr. Weishar. Good to see you. Counsel for Montgomery County, Maryland.
Good morning, Chairman, Commissioners. Lisa Brennan on behalf of Montgomery County, Maryland. I'd also like to enter the appearance of Jim Agorzalak.
Thank you, Ms. Brennan.
Thank you.
Counsel for Walmart Corporation.
Good morning, Chairman. Having some technical difficulties. Hopefully you can hear me. Derek Williamson from Spillman Thomas and Battle, representing Walmart, along with Barry Naum and Don Parker.
Thank you, Mr. Williamson. We could hear you loud and clear. Counsel for Pepco and Delmarva Power and Light.
Good morning, Mr. Chairman and Commissioners. Matthew Seegers appearing for Pepco and Delmarva. I'd like to enter the appearance of Douglas E. McKeel and Kim F. Hassan.
Thank you, Mr. Seegers. Next, we have the Maryland Energy Group.
Thank you, Mr. Chairman, Commissioners. David Bugelmans on behalf of the Maryland Energy Group. I'd also like to enter the appearance of Margaret M. Withering.
Thank you, Mr. Bugelmans. Are there any other parties that filed petitions to intervene that I neglected to call? Okay, thank you. We have two filings that were recently made by both PSC Staff Counsel as well as Office of People's Counsel opposing the petition to intervene of the PHI companies, that is Pepco and Delmarva Power and Light. The commission has since reviewed the two motions to oppose PHI's petition. Mr. Seegers, I'll give you an opportunity to respond.
Thank you very much, Your Honor, and once again, good morning. Essentially, I would like, in response to the filings of first of all, OPC contends that Pepco and Delmarva Power's interests can be adequately represented in this proceeding by Baltimore Gas and Electric. This on its face is just simply inaccurate. BGE, Pepco, and Delmarva Power are completely separate utilities with their own tariffs, their own rates, service territories, and customer bases. Because of this, issues that arise in any proceeding could affect each of the three utilities differently. Moreover, the commission regulates each of the three utilities as a separate entity. And one example is the requirement of a cross-fence filings from the merger order. Therefore, it's simply inaccurate to assert that any of the three Exelon utilities can adequately represent the interests of the other two. And I would also note that in this proceeding, BGE's primary concern is the current rate application order under consideration by the Commission, whereas Pepco and Delmarva Power's concern is how this proceeding will affect future multi-year rate plan filings. Moreover, I would note that there is precedent for allowing all three of the utilities to participate in the same proceeding. For example, in Pepco and Delmarva Power's ongoing standard offer service cash working capital proceeding, that is case numbers 9226 and 9232, BGE has intervened as a party because, as BGE stated in its petition to intervene, BGE will be affected by and has a direct interest in the outcome of this proceeding. And in that proceeding, BGE has filed testimony, sponsored a witness that was subject to cross-examination, and submitted briefs and appeal memoranda. Likewise, Pepco and Delmarva Power were permitted to intervene in BGE's standard offer service cash working capital proceeding. That is case number 9221, because, as Pepco and Delmarva Power stated in their intervention, Pepco and Delmarva Power may be impacted by the decisions of the Commission in this proceeding. And in that proceeding, we have filed various appeal memoranda in that proceeding. In contrast, nowhere in their filings do staff or OPC cite to any case where a petition to intervene was denied on the grounds that they are arguing. The second point I would like to make is that both OPC and staff assert that if provided full party status, Pepco and Delmarva Power will unfairly provide Exelon with, quote, 2 bites at the apple, unquote, and that our participation will overstretch the resources of other parties in this proceeding and overly complicate matters. First of all, at this time, Your Honor, I would like to note that Pepco and Delmarva Power do not plan on being active parties in this proceeding. However, even if we were to become active parties in this proceeding, it is in fact common in rate cases for the interests of parties like staff, OPC, and other interveners to coincide. For example, many interveners in rate cases have a common interest in reducing the revenue requirement and the return on equity proposed by a utility. But this fact does not serve as a bar to allowing interveners to participate in proceedings, nor is there ever any concern expressed about overstretching the resources of a utility from having to defend against multiple parties who often have similar interests. And the last point I would make, Mr. Chairman, is that contrary to staff's assertion in this filing, this is not an ordinary run-of-the-mill rate case. This proceeding is unique because it is the first multi-year rate plan that the Maryland Commission has considered. As the Commission noted in its order number 89482, this proceeding is intended to be a pilot, which is to evaluate the use of multi-year rate plans, after which regulations will be promulgated. And in fact, OPC's own filing concedes on page 3 that, quote, the Commission orders arising out of this proceeding could very well impact the future multi-year in this state. So while Delmarva Power and Pepco at this time do not plan on being active parties to this proceeding, because the Commission's determinations in this proceeding could very well affect future multi-year rate plans, we are intervening to ensure that we have the ability to weigh in on behalf of our interest and those of our customers. I thank you very much, Mr. Chairman, and I'm available for any questions.
Thank you, Mr. Seegers. I'll permit either OPC or Commission staff the opportunity to respond if they would.
Yes, Your Honor. Nick Garofalo on behalf of Commission staff. This is the time for Pepco and Delmarva to express what they wanted to see in a multi-year rate plan was in the proceeding, PC 53, and in the work group, or they could have even asked for reconsideration of your order, or they could have sought appeal. This is we do believe this is at heart a base rate case. It's applicable to BGE, and it really is important that it proceed with a single utility. After all utilities in the state and potentially all 25 or 30 members of the working group could asked to intervene on the same basis that Pepco and Delmarva have. We would strongly urge you not to grant the PHI company's intervention.
Ms. Garofalo.
Good morning, Your Honor. Joe Cleaver on behalf of the Maryland Office of People's Counsel. Your Honors, I think there's a circularity to what Mr. Seegers is saying. On one hand, he's saying, well, this is, we've never had a case like this, and it's this generally important case, and therefore we need to be involved. But yet the only rationale he can come up with for why BGE doesn't adequately represent his interest is to distinguish his clients, particularly Pepco and Delmarva, from BGE on the basis that they have separate service territories and that they're separate utilities. Well, and that this is a case affecting BGE's rates. And I think he said something about, their focus is on the rate application. Well, if we limit it, if we view it that way and only look at it as a rate application and look at, the fact that BGE is a unique utility with a specific service territory, well, in that respect, Pepco and PHI haven't articulated what their interests are in such a proceeding. On the other hand, when you look at it from the perspective of this is a new case in Maryland and we're dealing with a new type of rate making, well, in that respect, as we've set forth in our paper, BGE, PHI, and Delmarva have been through a long process at the commission throughout multiple dockets now, where the parties have spent an inordinate amount of time looking at these issues, talking about them, litigating them, setting forth their positions in filings, and not once have either of these parties taken a position at odds with one another. And again, Mr. Seeger says, well, we don't intend to be active, but we want to be there in case we need to be. Well, he hasn't shown the commission how BGE would not adequately represent the interests of their fellow Exelon utilities in the event that there's some MRP structural issue that comes before the commission in this case that the commission decides where BGE wouldn't adequately represent their interests. So for those reasons and for the reasons set forth in our paper of June 10th, we would oppose the Pepco and Delmarva petition to intervene and ask this commission to deny it.
Thank you, Mr. Cleaver. In reviewing Public Utilities Article 3-106B, the commission must grant leave to intervene to an entity unless the commission concludes that parties to the proceeding adequately represent the interests of the person seeking to intervene. In this case, the parties BGE and the person would be their Exelon affiliate, PHI. I concur with the position of OPC and staff here that throughout the PC 51 process, the Exelon companies, BGE, Delmarva, and Pepco, did not show any daylight between their positions. They did, as OPC claims, speak as one voice. Obviously, there's nothing stopping counsel for PHI to collaborate and work with BGE behind the scenes as they work through this first of a kind multi-year rate case. But I think it would be uncommon for PHI to be intervening and participating in this case. Once you have party status, you do have the rights associated with that in Chapter 3 of the PUA, Section 3 of the PUA, including cross-examination, whether or not, Mr. Seegers, your party actually, your companies actually intend to do that. We also stated in the multi-year rate case that we issued the order approving multi-year rates earlier this year, that one of the benefits would be to streamline the process. And even though none of the parties raised this issue in their pleadings this past week, I seem to recall that lowering rate case expenses was one of the benefits associated with a multi-year rate case. And to have two Exelon utilities participating in the same proceeding would seem to walk back some of those intended benefits. As I just mentioned, there's no bar to DPL and PHI working or even collaborating with counsel for BGE as they move forward with their strategy in this litigated rate proceeding. But I do find that the interests of PHI are fully represented by Baltimore Gas and Electric. And for those reasons, the petition for PHI to intervene in this proceeding is denied. Moving to the other petitions that were filed, do parties have concerns with the petitions filed by Amtrak, Department of Defense, Montgomery County, Walmart, or the Maryland Energy Group?
Staff does not object to any of those petitions, Your Honor.
Thank you, Ms. Garofalo. And hearing no other party objecting to those petitions are granted. We'll turn back to Mr. Ralph. Do you have any exhibits to introduce in this proceeding? Your mute button is on, Mr. Ralph.
Okay, there we go. I think it's off now. It took a second to get off. Yes, Your Honor, we'd like to publication. In compliance with this commission's order 89556, BGE filed with the commission its proof of publication on June 10th of this year, wherein BGE certified that it published notice of the pre-hearing conference twice in a paper of general jurisdiction, general circulation in BGE service territory, as well as posted such notice on its homepage, its BGE app, and through its social media accounts. With that, Your Honor, I'd like to move BGE's publication certification into evidence as Company Exhibit 1.
Thank you, Mr. Ralph. I see those exhibits were filed 2 days ago, and BGE exhibit number 1 is moved into evidence. Thank you. Do we have a procedural schedule that has been agreed to by the parties and interested persons today?
We do have such a document. I believe it was circulated this morning to the commission. And I do not believe there is any, anyone has any objection to the dates proposed.
Thank you. I do know that I was reviewing that. I see the very last item when the informational filing for 2020 rate base only is noted as March 31st, 2020. I believe that should be March 31st, 2021. Is that correct?
You're correct.
Okay. Ms. Garofalo, just for the record, do you want to run through the timetable?
Certainly. The pre-hearing conference is noted on there, and it is today. Interventions have been filed, and the application was filed on May 15th. We ask that direct testimony be filed on Friday, August 14th, with rebuttal, at which time BGE will also update the COVID-19 regulatory cost to be filed September 11th, 2020. So rebuttal testimony to be filed Wednesday, October 7th, and the evidentiary hearings the week of, from October 13th through October 21st. Initial briefs will be filed Wednesday, November 4th, and reply briefs November 12th. The order is noted here on December 16th, but perhaps BGE would like to address the exact details of how that final order will work out. Well, if not, let me say that the company has
I think Mr. Ralph was about to jump in.
Oh, sorry.
Yeah, I was just going to say, Bev Sikora, who's in this case and on this line, she'll address the schedule issues regarding the case. Might be having a little technical trouble.
Sorry, I forgot to unmute my phone as well as the computer. Good morning, Chairman Stanek and Commissioners. Yes, the company, given the issues in this case and the concern about timing, has agreed to extend the suspension period by 5 days at this time so that the commission's order would be due by December 16th. However, given that the rates would not become effective till January 1st, we would be willing later in the case to revisit that issue, the extension of the procedural schedule to perhaps allow additional time if needed. We're uncomfortable extending it any further, given that this is a unique case and one of, the first of its kind. We don't want to leave ourselves short with time to implement the rates, but perhaps as the case goes on and things become clear and we are less concerned that there could be any issues arising from the order that may make it more difficult to implement the rates, we may be willing to further extend the suspension period to allow more time for the commission to issue its order and perhaps even more time for the parties for briefing or anything like that.
Thank you, Ms. Sikora. Ms. Garofalo, anything further?
Mr. Chairman, this is Commissioner Herman. I had a question for staff or the company. Help me explain what you mean by the informational filing that's coming in March of 2021. Presumably, it says on the document that that's information about 2020. So I'm just trying to make sure I understand. Are both of those dates meant to be 2021? And what do you mean by informational filing that's coming in March of 21? Or help me explain what that filing is.
Yes, Your Honor. We realize that, the rates for 2021 are predicated on the year-end 2020 rate-base balance, which at this time is based on projections. So we would provide actual 2020 rate base amounts in that informational filing. So that's similar to the other informational filings. The party could see if there was any significant variation between the projected and actual rate base to determine if there needed to be any kind of adjustment to the rates, similar to the other informational filings that will be happening in the future years.
Okay, thank you very much. I just wanted to make sure that I had the dates straight in my head. I appreciate it. Thank you, Mr. Chairman.
I apologize for the typo.
Thank you. Do any parties object to the procedural schedule as described by Ms. Garofalo? Hearing no objections, the procedural schedule is adopted. Ms. Garofalo, have the parties agreed to discovery schedule?
We have, Your Honor. For discovery period would be 10 business days through the filing of the intervener's direct, after which it would be 7 business days until the filing of the rebuttal testimony, and after which it would be 5 business days through the hearing.
Thank you. Do any parties have discovery rules? Hearing none, those discovery rules are adopted. Pursuant to the order issued on May 8th, 2020 in Order 89556, discovery has commenced for staff, BGE, and Office of People's Counsel. Discovery will commence today for all other parties whose petitions were granted. If there are any disputes, and I hope they are limited, those discovery disputes should be brought to the Commission's attention as quickly as possible. With that, we are wrapping up this pre-hearing conference. Do any other parties wish to inquire of the bench or have any motions or requests before we conclude today?
Your Honor, staff has one preliminary issue that Mr. Dean will present.
Good morning, Mr. Dean.
Good morning, Your Honor. I hope my mute is off now.
Your mute is off. We hear you loud and clear.
Thank you, Your Honor. Briefly, This is intended to be informational as staff is still developing the scope and identification of an issue involving forecasted data in the application. However, staff is not asking for any commission determination or action at this time at this hearing. For a multi-year rate case with rate changes occurring years after the final order, the data and methods used to develop its forecasts are critical. However, in several cases, it appears to staff that the application lacks critical information regarding forecasted data. Section 3F of the December 2019 implementation report that the Public Utility Law Judge Division filed in case number 9618 lists several items that must be filed for forecasted data. However, in many cases, it appears that the information is missing or simply listed without explanation. For example, the implementation report requires a discussion and narrative that outlines the information on the methodology used that underline each forecast, but in the filing submittal, BGE briefly describes load forecasting. Briefly describes the load forecasting team, what inputs it uses, and their objectives. They state that they did not review any other methods because they use modeling techniques that are considered the industry standard. Another required item in the report is other methods reviewed and the reasons they were not used. However, here BGE essentially states they did not review other methods because they use modeling techniques that they consider to be the industry standard. In section 5-1 of the implementation report, in response to the question, what should the utilities file at the onset of the rate case in order to reduce the asymmetricies of information, the implementation report states that in addition to spreadsheets, additionally, the utilities should include in their filings detailed explanations of all methods used to develop the proposed revenue requirement and rates, as well as detailed explanations for why the specific decisions in the filing are reasonable. The utilities should also include in their filings the benefits to be achieved by their investments, both quantitatively and qualitatively, in terms of metrics that will be affected or cost savings achieved. However, for the forecasted data, there is no supporting testimony provided in the application, and currently, for the most part, even with discovery, staff is only obtaining the numbers. For example, for accounting information, BGE's filing does include category level forecasted cost and actual 2019 costs, and if applicable, details for projects within each category, including a problem statement and a solution statement for capital projects greater than $1 million. However, there is nothing stating why the forecasted projects and costs are reasonable. Now, staff is working with BGE and has discussed this issue, and it is possible we may be able to come up with a resolution of it. But at this time, it remains unresolved, so staff is notifying the commission of this issue, which staff sees as involving the adequacy and completeness of the application. However, staff is still working to establish and clearly identify the scope of this issue. Thank you.
Thank you, Mr. Dean. You've placed staff's concerns on the record today. I trust that BGE will continue to be responsive in order to resolve the information that you currently lack. Again, if there is disputes going forward as to the ability to obtain information as outlined in the Commission's multi-year rate order, you may bring that concern or discovery dispute to the Commission's attention. And I would hope that BGE uses best efforts to communicate and work with staff to get them the information they apparently need. Are there other matters before the commission today? Hearing none, we'll see everybody back here in October, whether it be virtually or in person in some way, shape, or form. With that, this conference is adjourned. Have a good day.
Thank you.
Thank you.